Good morning, everyone. So Robert and I are going to go over three bills specifically that will affect you coming up, actually, as soon as this Friday, from the 85th regular legislative session. So I know that there's some materials that we provided, our PowerPoint. Following those materials, we have provided the text of the three bills that we're going to discuss. And because we're attorneys and we're not anything if not difficult, we are going to go in reverse order, starting with Senate Bill 2065. So if you're trying to follow along and you can't, it's okay, but I just wanted you to know that the text of the bills that we're covering is in the materials following our PowerPoint. So we're going to cover Senate Bill 2065, and that is a bill that, it's a fairly large bill, so I've provided just the excerpt of the relevant provisions. Specifically, there's changes to the Business and Commerce Code that affect different occupational licenses. What we'll kind of flesh out a little bit, and Robert will go into more detail, is the prohibition against implying that you practice as an attorney, but also changes to the government code that specifically say when you can charge for fees that are associated with certain types of services. Then we're going to discuss Senate Bill 1098. There's two main changes to that bill that affect the government code. One will be a change for you guys out there. The other is kind of just a modernizing of the language and will probably be in line with what you're already doing in terms of providing things in your record book. And then finally, we will cover House Bill 1217, which is kind of the best for last, the online notary bill, also the remote notary bill. Keep in mind that the first two bills we cover, they go into effect on Friday, September 1st. The online notary bill, that is not until next year, July of 2018. So Robert, can you tell us what we need to know about Senate Bill 2065?
As you know, as notaries, we may not represent ourselves as lawyers. Senate Bill 265 did two things. First, it amended the Deceptive Trade Practices Act to add the terms immigration consultant and immigration expert to the laundry list of terms that a notary may not use in advertising their services in a foreign language in order to imply that they are authorized to practice law in Texas. But the bill also amended the government code to say that providing language translation and typing services did not constitute the practice of law. So some notaries do provide those additional services of translation and typing. That's perfectly okay. It's not something that is going to get you in trouble with our office. And then you wanted to...
So Robert, you mentioned the fees, and Kathleen also briefly touched on, obviously there's fees that you can charge and there's a statutory amount for official notarial acts, but the type of fees for the printing and translation services, what would be a best practice if you are going to charge for that?
It's very important, as Kathleen said, to itemize, and it's not something that's fun to do, but we get complaints from people who say they received a $50 bill from the notary and a notary can only charge $6. Well, both of those are true, because the additional services rendered by the notary were for other services. But if you don't itemize your fees, then it becomes very confusing to your signing parties and to us when we get the complaint as to what that fee was for. So it's a best practice to arrive at a fee, an agreed fee, before you provide the service, whether or not you're going to charge for travel or copies or whatever you're going to charge for. Make sure that you agree with the signing party in advance what the fee is going to be, and itemize it in a written statement. And then if some problem comes up down the road, you'll have a record of what you charge and why you charge for it. It's just saves a lot of trouble if you do it that way.
Okay, so moving on to Senate Bill 1098, I mentioned before that there's two changes that everyone out there should know. One of them is a change. So in your record book now, you have to record specific information, right? This isn't news to any of you. But one change is that, so for example, when you're recording the signer, grantor, or maker's residence or alleged residence, that sounds familiar, right? Now, anytime you saw that language, it's been replaced with mailing address. This is to protect privacy concerns so that you don't have to necessarily take down someone's residence. So anywhere where it was previously said residence or alleged residence, it's now mailing address. So that will be a change.
And your mailing address can be your office, it can be a post office box, it can be any mailing address.
And there's
so-
also corresponding changes in the Civil Practice and Remedies Code to reflect that. The second change in 1098 that makes the government code is upon demand and receipt of fees, if a notary is asked to provide a certified copy of their record book. Previously, you were asked to provide certified copies of any record in your office. This was a little ambiguous and outdated, so we changed that language to basically say that you provide in your book of record all official acts, which is probably something you were already doing, so this is more of a modernizing of the language. And I think that covers 1098, but just keep in mind, no longer residence or alleged residence, it's now mailing address. So we'll move on to the big one, the best for last, which is House Bill 1217, which is also known as the online notary bill and also known as the remote notary bill. Again, everyone, please keep in mind this does not go into effect until July 1st, 2018.
And also, we anticipate we will see lots of questions asking us, do I have to be an online notary? The answer is no, it's purely voluntary. Texas was the third state to adopt remote notary procedures. We're followed closely by Nevada. Kathleen said this morning that Ohio is in the process perhaps, but it's a very early field in how this is going to work. In Virginia's experience, a very small number of people became able to become online notaries, and we anticipate it will be the same way in Texas, that if you have a client that wants you to perform that service in that way, you'll probably want to do that. But it may not be something you need to rush right out and do because there are going to be costs associated with it. You will have to register with our office to be an online notary. You will also need to purchase software to provide the electronic notarization involved. There will also be software that you'll need to purchase because the identification procedure for your acting as an online notary is much stricter than it is now. And you can understand why. If you're doing a notarization over Skype or whatever, the person is not in your physical presence, and so you're going to take additional steps as to how that's going to work. Our office will be adopting, or at least proposing, administrative rules to tell you exactly how that's going to work. You'll have an opportunity to comment on those rules before they are actually proposed by our office, and we urge you to do that because it's, in a lot of ways, it's a brave new world in this particular procedure. And so it is something that we are going to spend the next 10 months working on very diligently, and it will become effective on the 1st of July of 2018. Both the statute and the rules will become effective on that date. We're not going to get further into the weeds because, frankly, we don't even know where the weeds are right now. We're still working our way through. Hopefully that Kathleen and some other experts in the field will help us work our way through it. But it's also an exciting time, and we think that this process will make notarizations more available to people, especially in remote areas. So we're looking forward to that process.
And let me ask you a quick question, Robert. If you want to be an online notary but not a Texas Notary Public through the regular channels, is that possible?
It is not. You will first need to go through and become a regular notary, or if you already are a regular notary, then you can apply to become an electronic notary. But you first must be a regular notary before you can become an online notary.
And we all know it's a 4-year commission, so say I have about 6 months left on my commission and I decide I want to be an online notary. Will I have dueling commissions and different start dates, or?
The dates will be coterminal, so whenever you apply, if you're already a regular notary and you apply to be an online notary, your term for your online notary will be the same term as for the regular notary. It'll just make it easier for everybody.
And really quick, you mentioned that there would be software that you would need to get. Is that something that the secretary will be providing you?
We will not be providing the software. We will be drafting the standards that software providers must meet in order to make this process work, but it will be something that you will be purchasing from private vendors.
So stay tuned for more information on HB 1217, and then keep in mind that the first two we discussed do go into effect on Friday. Other than that,
Thank you very much.
thank you.